saved is money earned. I have been trying to follow his footsteps, but somehow this complex issue of taxation never helps me to come out of it. Today, we have been fortunate enough to have amongst us a senior member of our bar, Sri Saurabh Soparkar, to help us solve this technical issue in best way possible. To give a brief introduction, may I invite our bar president, Sri Asim Pandya, to say a few words.
Respected senior members and my colleagues at the bar. Good evening to all. I am indeed very glad to welcome you all to this legal talk organized by our association. Our association organized the first lecture in this year in the month of June. In the first lecture, we invited Mr. Dushyant Dave, Senior Advocate, Supreme Court of India. Mr. Dushyant Dave shared his thoughts on the topic administration of justice and the role of bar. This is a second lecture organized by our association. The association is committed to arrange many more lectures for the benefit of the members of the bar during this year. Continuing legal education and keeping the members of the association abreast with the development in law is the main aim of the association. In pursuit of this aim, today we have arranged a lecture on the topic legal profession and tax planning. Today, we have with us Mr. Saurabh Soparkar, Senior Advocate and Tax Expert, to deliver the lecture on this topic. Mr. Soparkar will explain us the important aspect of tax planning in relation to the legal profession. Mr. Soparkar needs no introduction to this august audience. However, I would be failing in my duty if I do not speak a few words about him. Mr. Soparkar is an eminent lawyer practicing commercial tax and tax laws. He is a most sought after speaker after the presentation of the union budget every year. He is invited all over India to speak on budget and tax proposals made in the budget. He regularly delivers lectures in many prestigious institutions on the company laws also. Our association is very lucky to have a member like Mr. Soparkar, who has always shown willingness to share his knowledge with the members of the bar, irrespective of the constraints of time. Without taking much of your time, I now request Mr. Soparkar to come to the podium and deliver his speech on the topic legal profession and tax planning. Please welcome Mr. Saurabh Soparkar with a big round of applause. Thank you very much.
Mr. President, sir, friends, it's a pleasure to be here this evening to share some of my thoughts on the interesting topic of the profession of law and tax planning. It's interesting because as lawyers, we always advise others, but like all advisors are not very keen to receive advice of others. And though like death, tax is a certainty, just as we treat death to be as far away as possible, we also try to be as far away as possible from the pains of paying tax. I am not saying we don't accept the obligation, but as is the human tendency, we try to avoid, to the extent possible, payment of taxes. What I would be doing would be taking you to some general avenues of planning, and in particular a new provision introduced this year for the benefit of lawyers, where a special scheme for taxing income is being introduced. But before I really go there, I must take you to a little historical background. Under the British Raj, for more than a century we did not have any taxes. Then came 1857, what we call is the freedom fight, Badwo. And the British government ended up spending significant amount resisting the 1857 revolt. As a result, for the first time in 1861, income tax came to be levied with tax at 4% on the income in excess of rupees 500 per annum. In their 1866, the rate of tax came down from 4% to 2%, and which went on for some time. Exactly 100 years thereafter, position was exactly reverse. From 1866 we come to 1966, 67, 68, 100 years thereafter, the position was reverse. And we had in this country, some of you were not born, and I am sure none of you were paying income tax in that year. We had in late 60s, rate of income tax going as high as 97.75%. So if we earn income in those days of in excess of rupees 15 lakh, you have to pay rupees 97 and 75 paisa to Government of India, and you are permitted to keep change of rupees 2 and 25 paisa in your pocket. Apart from 97.75% of income tax, you were also liable to pay wealth tax, which was 5% of your wealth. If you happen to die, Government of India was your first heir, because as high as 60% of your wealth will be taken away in estate duty. If you receive gift, you were liable to pay gift tax. Now, why am I discussing this? I am discussing this because in less than 50 years, we have moved significantly in favor of the taxpayers. Wealth tax is abolished, estate duty is abolished, gift tax is abolished, and income tax has come down from 97.75% to practically 33%, or for all purposes 30%. It's only those who earn income in excess of rupees 1 crore that they have to pay tax at 33%. 30% is the maximum rate of tax that an individual pays, which is, to say the least, most reasonable rate of tax. I am here to discuss planning, and I am not here to preach everyone must pay taxes honestly. That's not the idea. But I would take a view that one must try to ensure that to the extent possible, you end up, after paying tax, save as much as you can. Planning is not to evade. There is a distinction between planning and avoidance, planning and avoidance and evasion. Idea is not to evade, idea is to plan. But in spite of planning, if you have income which is good enough that requires you to pay tax, please do not go by the temptation not to pay tax. Let me give you a brief reason as to why it may be necessary to pay taxes. It's only if you pay taxes, you can build your capital. It's only when you pay taxes, you can acquire legitimately assets including land, building, offices, residential houses, so on and so forth. This is one profession next to the profession of medicine, where in a large number of cases, the significant portion of the receipts would be in cash. It's only in case of corporate clients that one ends up getting check fees, but otherwise by and large you get cash fees. And temptation is not to show whole or part of the receipts. Effect is that monies don't get deposited in the bank. Effect is that money gets spent away, frittered away. And if suddenly there is some need for some kind of money, hospitalization, foreign education, for construction of a house, You suddenly find that you don't have money left with you because whatever you have spent away. And therefore, it is necessary to see that to the extent possible you pay taxes for the purpose of ensuring that you have enough capital. Second and more important, my experience has been that in recent past, Income Tax Department has been far more intelligent and incisive as compared to what was 20 years back. All of us may feel, how would the department know as to how much income have I earned? How many wakalatnamas are filed by any advocate is known from the website. So if an assessing officer wants to find out how many matters have been filed by a lawyer, especially for High Court, he can easily access the website. And if you say that, okay, my receipt is only rupees 20 lakh in a year because I had filed 200 matters in the year, the assessing officer can as well point out, sir, you are saying you have filed 200 matters, but High Court website shows 400 matters. And then you may have a problem. Therefore, with information and technology which is making life of everyone in a way easy and in a way difficult, please don't have temptation of not showing the income because you are likely to be caught quite easily. Having said this, let me now go to some of the issues with which lawyers would be concerned and otherwise. If you look at the position of law today, it is reasonably simple in the matter of rate of tax. If you have an income up to rupees 2.5 lakh on a yearly basis, no tax. If you have income in excess of rupees 2.5 lakh up to rupees 5 lakh, tax at the rate of 10%. If your income is in excess of rupees 5 lakh up to rupees 10 lakh, tax at 20%. And for income in excess of rupees 10 lakh, tax at 30%. So depending upon what is the level of your income, you decide what is the amount of tax that is required to be paid. When I say income over here, what I mean is taxable income. So from the total, you are entitled to all deductions, expenses, certain other deductions to which I will briefly refer to, and then what is remaining in your hand, you are liable to pay income tax. Receipts are not income. From the receipts that you get, you are entitled to claim deduction of every expenditure that you legitimately incur. When I say expenditure legitimately that you may incur would mean expenditure that you are incurring for the purpose of carrying out the profession. Books, clerkage, salary, traveling, motor car expenses, everything is admissible for deduction. And thereafter what you have as a net is the net professional income, which will have to be counted for the purpose of income tax. So if you have income of, let's say, receipt of 25, 30, 35 lakh, you find out what is your receipt, find out what are the expenses that you have incurred, net whatever remains becomes your professional income. Let me first go to the specific provision which is admissible to lawyers from this year, which is very, very important and very, very interesting. There was always a resistance from certain professionals, lawyers, doctors, chartered accountants, architects, engineers, who were having income to the extent of, let's say, middle level, that you are expecting us to maintain books of account, record, details, everything. The law requires that otherwise if your receipts are in excess of rupees 1.5 lakh, you must maintain books of account. You must maintain cash book, you must maintain ledger, you must maintain receipt book, you must maintain all vouchers, you must keep records, and you must write down everything in the books of account. This was creating some kind of dissatisfaction, and there was always a dispute between the department and the SSCs as to what is the income that you have earned. From this year, there is a new provision. If the professional's receipt is not more than rupees 50 lakh, I am talking about receipt. The law says you are entitled to take a position that my income from the receipt is equal to 50% of receipt. So take a situation, your receipts are rupees 40 lakh. Either you maintain books of account and prove that your income from the receipt of rupees 40 lakh is whatever you want to claim, or if you don't want to have any hassle, if your receipts are 40 lakh of rupees, you pay tax on income of rupees 20 lakh. So you don't need to maintain any books of account, you don't need to maintain any record, you don't need to maintain any details, just you need to have one information: what is my receipt during the year? How do you find that out? You would find that out on the basis of what you have deposited in the bank and what you have otherwise kept on hand. Because suppose you have deposited everything in the bank which you have ultimately invested or saved, then certainly you have got some money for the purpose of keeping your family